All right, so my name is Barbara Zabawa. Thank you so much for letting me speak to you today. I'm an attorney, and I'm the founder of the Center for Health and Wellness Law, and I'm here to persuade you today for the need for wellness law. So what is it? What is wellness law? It is a new legal practice area that studies and advises on the laws that impact wellness activities, and it combines health, labor and employment, and employee benefits legal practice areas. What does the wellness law cover? It covers HIPAA and the Americans with Disabilities Act, and with regard to HIPAA, it covers non-discrimination and the privacy and security rules, and it applies to group health plans only. And with the Americans with Disabilities Act, it covers all wellness programs, but particularly those that are collecting employee health information. It also covers GINA, the Genetic Information Non-Discrimination Act, and it applies to wellness programs that are either collecting employee family medical history information or asking spouses of employees to participate in HRAs or biometric screens. It covers the Fair Labor Standards Act, the Internal Revenue Code, and licensing laws. With the FLSA, it would be implicated if an employer is asking employees to do wellness activities, actually requiring them during work time. With the IRC, if the employer is offering incentives that are subject to tax withholding and income tax laws. And licensing can impact clinical laboratory as well as scope of practice rules. So why is it needed? Well, there are a lot of stakeholders, as you all know, in the wellness industry, and these stakeholders are expected to know and comply with various laws that affect wellness programs. And so the list you saw, and it's needed because these stakeholders lack resources currently about wellness compliance. Current legal practice areas of health, labor and employment, and employee benefits leave gaps in understanding the needs and missions of these stakeholders, so your legal advice may not be that satisfactory, and wellness law is trying to fill in those gaps. An example, HIPAA privacy and security compliance. Most traditional health lawyers have a hard time applying security and privacy rules to wellness companies because they're not technically, in a lot of circumstances, covered entities. And employee benefits lawyers may not realize that not all wellness programs are tied to group health plans, and so that is a gap. Moreover, laws that impact workplace wellness programs can be used to design more effective and more inclusive programs. And that's a big one for me. Let me give you an example. The ADA Equal Opportunity Requirement. That's a requirement that requires wellness programs to provide equal opportunity for all employees to enjoy the terms of their employment. That should force wellness programs designers to consider the abilities of all their employees to ensure they can participate. Increased participation can increase effectiveness. So who practices wellness law? Well, right now, not very many lawyers because it's so new. Most of the lawyers who advise employers on wellness issues are employee benefit attorneys, and they also have duties with retirement and compensation issues, and brokers can also practice in the wellness law arena. I practice it. I've written a book about it. It's called Rule the Rules of Workplace Wellness Programs. It's coming out in April, being published by the American Bar Association. Hopefully, it will increase interest by the legal community in wellness law. It's my hope. How is it practiced? It's practiced with a preventive law approach, which is my approach, by incorporating compliance into the wellness program design up front. Hopefully that minimizes the risk of scrutiny by government agencies as well as by others like former employees. So it could also be a litigation specialty, not my area, but that could encompass lawyers defending wellness programs against lawsuits from disgruntled employees or bringing lawsuits on behalf of those disgruntled employees, which is what we saw in the Flambeau, Orion Energy, and Honeywell cases. Another type of wellness law litigation case that has not happened yet, but I believe could be out there, is under the Fair Labor Standards Act, bringing a class action where employees are alleging that their employer is requiring them to do a wellness activity during their work time and not paying them for that time, similar to the Donning and Duffy cases. The AARP lawsuit's another example of a wellness litigation where the AARP said the EEOC's rules were violating employee privacy. The district court on December 29th said that those rules are valid for now, at least. Where is it practiced? Because most of the laws that impact wellness programs are national, it can be a national, or federal, it can be a national practice. But to the extent there are state laws, attorneys can consult with attorneys licensed in those states. One relevant state law is a state anti-gambling law. That may impact employers who hold raffles as a wellness activity incentive. States like my state, Wisconsin, restrict raffles to certain types of organizations, and those organizations often need a permit. How will the new Trump administration impact wellness law? Well, talk of repeal of the Affordable Care Act should not impact the HIPAA ACA rules. One, because they're not tied to a budget provision, so any budget reconciliation law should not affect those rules. Plus, Congress is generally in favor of those rules. However, they're not fans of the new EEOC rules, generally speaking. But those are not tied to the Affordable Care Act. So what might happen is the Trump administration might say to the EEOC, don't enforce those rules, which would then leave enforcement to disgruntled employees. And that is all I had for you. Thank you.